Good afternoon, everybody. It's my pleasure to be with you this afternoon to present on a legal topic that I'm passionate about, and that's protection orders and other information related to the Domestic Violence and Stalking Act. I'll indicate at the outset the poll question, we'll get to the answer fairly quickly in my presentation. So that's probably why Maury has left it for me. So I'm going to go through a number of slides over the next 60 to 70 minutes. There's a lot of information to go through with respect to the Domestic Violence and Stalking Act. And as we know, particularly, we're going to be talking about the legal provisions relating to protection orders, the law, and the process when someone applies for a protection order. Next slide, please. Okay, so this slide is a brief summary of the topics that I'm going to cover this afternoon. I'm going to start off by going over a very brief review of what the Domestic Violence and Stalking Act provides for in terms of protective relief. I'm going to move on to protection orders, and that's really going to be the substance of the presentation this afternoon. I'm going to review the key protection order provisions in the DVSA, which is, as you can figure, that's the acronym I'm going to use this afternoon for the Domestic Violence and Stalking Act. We'll talk about the role of the Judicial Justice of the Peace in the protection order application hearing process. We'll review the provisions in the DVSA that are the criteria that the JJP needs to consider in order to grant a protection order. And then finally, if a protection order has been granted by the JJP, we're going to review the conditions that can be included in a protection order. Lastly, we're going to end the presentation with just a couple of slides of information dealing with, okay, if a protection order application is successful and the protection order is granted, what happens next? If a protection order is denied, what are the options to a victim applying for a protection order, be that a prevention order or any other options under the DVSA? Next slide, please. Okay, so I don't know, for those of you that have been around as long as I have, you can probably remember what the law provided for prior to the end of the 1990s, but I'm not going to get into that this afternoon. Suffice it to say that the Domestic Violence and Stalking Act is legislation that's been in place for well over 2 decades now. It came into force on September 30th, 1999. In very broad terms, the Act provides for 2 different types of civil protective orders: protection orders and prevention orders. So just a quick summary of the main aspects or characteristics of a protection order. It's obtained by a person on application to a Judicial Justice of the Peace, or what I'll be referring to as a JJP, of the provincial court. Applications for a protection order are intended to proceed in a quick, inexpensive, and relatively straightforward manner. And I feel like I have to use air quotes when I say quick, inexpensive. I mean quick, relatively speaking, from a legal perspective. Basically, an application for a protection order can take a whole morning or a whole afternoon, but compared to the way that our other court proceedings can take, it's quick, it's inexpensive, and it's relatively straightforward in the sense that there's application forms that are pre-printed. They need to be completed. There are other service providers in the field who can assist someone complete an application if they need to. Now, on an application, an applicant has to provide evidence under oath about the domestic violence or stalking. Next slide, please. The JJP has to consider the evidence that's presented by the applicant and the legislative provisions in the DVSA. They have to conclude that domestic violence or stalking either is currently occurring or has occurred in the past, that there's a reasonable likelihood that it's going to continue, and then finally, due to the seriousness or urgency of the circumstances, a protection order should be granted. The other type of protective order that can be granted under the DVSA is a prevention order. It's the other order that's granted by the other court in the process, and that's the Court of King's Bench. So a prevention order is a similar type of order to a protection order, but the process to be able to apply and have a prevention order is quite a bit different than the process for a protection order. A prevention order is also a court order intended to address domestic violence or stalking, but they are generally not orders that are intended for emergency situations. Next slide, please. So the application process for a prevention order takes longer than a protection order application. An application for a prevention order can take a few months or longer to be decided. Both parties to the prevention order process, the applicant and the respondent, have notice of the hearing. They can both attend at the hearing before the judge and both have a say in the applicant's request for a prevention order. So in this respect, a prevention order is very similar to other types of civil and family law court proceedings that take place in our Court of King's Bench. For a prevention order, having a lawyer is desirable but not mandatory, so it's not essential or required. A person can represent themselves if they want to. And then finally, if the applicant does not have legal aid, they will have to be responsible for the costs related to the filing fee for the notice of application. And if they decide to get a lawyer, they will also have legal fees. So that's also a marked difference from protection orders, where the process is set up that generally a person can do it themselves or with the assistance of someone else, and there is no application to file the fees. Next slide, please. Okay, so moving on to our presentation on protection orders. The first slide is just a brief summary of some of the key elements or characteristics of a prevention order. As I've mentioned, a protection order is a remedy that's available under the law. It's granted in emergency situations only where there's been domestic violence or stalking. It's considered an extraordinary or exceptional remedy in our legal system because the other side, the respondent, doesn't know that the application has been made. So the word or the phrase that we use is that the application is made without notice to the respondent. For good reason, it's to address an urgent or emergency situation, but it is an exceptional process and remedy under the law because of the fact that it doesn't proceed the way that the vast majority of other legal processes in our court system go ahead before the court. So the respondent is not present at the hearing. They have not been served with notice of the protection order application ahead of time. If a protection order is granted, the first time that the respondent will become aware of it is when they're served with it afterwards. Finally, the protection order has an expiry date. It's generally 3 years in duration, although it can be longer. Okay, Lori, I think you went back one slide. So can I get you, maybe, I think we now need to forward. There we are. Yeah, we're okay. All right. So this is the point in the presentation where I really move into the key provisions of the Domestic Violence and Stalking Act. So we start off by reviewing some of the key concepts and definitions or meanings that are in the Act. A lot of people are familiar with the DVSA in terms of general terms. They know that it's the legislation that someone can apply for a protection order on, but a lot of people haven't necessarily cracked open the legislation and gone through it in detail, but that's really one of the main purposes of this afternoon's presentation. So what does it actually say? A person who's applying for a protection order, for a lot of you on today's Zoom call, that's the person that you may consider the victim of IPV or family violence. For purposes of the DVSA, a person who applies for a protection order is called the subject or the applicant. For the purposes of the rest of my presentation this afternoon, I'm pretty much going to use the word applicant when describing the person that's applying for the protection order. The other person who has the protection order granted against them, so the person that we may be considering to be the abuser or the perpetrator, they're the respondent, the person who has the order granted against them if the order is made. Next slide, please. Okay, in very broad terms, there are two grounds to seek a protection order. And at the risk of coming across as glib, the grounds are domestic violence or stalking, right? They're right in the name of the legislation, but it's a little bit more nuanced than that. A person can apply for a protection order on the basis of domestic violence, but only certain categories of legal relationships are eligible under this legislation to be able to apply for a protection order on grounds of domestic violence. In general terms, the applicant and the respondent need to have had some sort of domestic or family relationship with one another. And the other ground is stalking. Stalking doesn't require the existence of some sort of domestic or family relationship. The parties may not have had any sort of legal relationship with one another. And examples of parties who can apply under the DVSA for a protection order on grounds of stalking would be co-workers, neighbors, or even complete strangers with one another. Next slide, please. So the terms are given specific definitions within the body of the legislation. Domestic violence is described as being an act or omission. An omission is not doing something or failing to do something. It's conduct or behavior that can be intentional, reckless, or threatened. It causes actual bodily harm or property damage, or there's a reasonable fear of bodily harm or property damage. So just taking those first couple of ones, it can be an actual assault or destruction of property, or it can be a verbal threat or language or body language that suggests that there may be bodily harm or property damage. So that reasonable fear, it doesn't have to actually be an assault or property damage, just the threat and fear of it on the part of the victim. Behavior that reasonably in all circumstances could be thought to cause psychological or emotional abuse. And then finally, the last two types of behavior, which are obviously very specific in the nature of the way they're described, forced confinement or sexual abuse, would also fit within the meaning of what constitutes domestic violence under the DVSA. Next slide, please. So to expand a little bit upon what I mentioned a minute ago about who are the categories of legal relationships that can apply for a protection order based on the grounds of domestic violence. And so the Act says that domestic violence occurs when a person is subjected to certain types of behavior by another person where they've lived together in a spousal or intimate relationship, where they currently have or have had a family relationship, whether or not they've lived together. So this covers a scenario where, maybe you've lived with a sibling or a parent, you maybe haven't lived with a grandparent. So this could cover, for example, elder abuse, a grandparent who's being badgered or manipulated by a grandchild to hand over money or to provide assets, for example. That would be an example. They would fall within that category and they would be able to apply for a protection order on grounds of domestic violence. The next category is they have or have had a dating relationship, whether or not they've ever lived together. That's all the Act says. It doesn't provide, any specific criteria. It has to be, like more than 5 dates. They constitute a dating relationship. Less than, it doesn't. It just simply says that they have or had a dating relationship, whether or not they've ever lived together. So in my mind, if someone has had one or more dates with someone and there's domestic violence or stalking, I would suggest that they apply for a protection order if there's been domestic violence or stalking. And then finally, the last eligible category where someone can seek a protection order on grounds of domestic violence would be if they have a child together, regardless of marital status or whether they've ever lived together. Now, that can cover a bunch of scenarios in today's day and age, but the example I usually give is, the one-night stand where two people hooked up, maybe after they met at a bar or a social or a party. They end up having sex and a child is born as a result of that one night together, but they otherwise didn't date. They never lived together. They didn't have any sort of domestic or intimate relationship. If they have a child together, then either party could apply for a protection order. Next slide, please. Okay, the meaning of stalking. Stalking occurs when a person, whether known or unknown to the victim, has no lawful excuse or authority to follow them or communicate with them, engages in repeated unwanted conduct, knows that the behavior is unwanted or is reckless as to whether the other person is harassed, causes the other person to reasonably fear for their personal safety, taking into account all of the circumstances. So I apologize that I just basically read verbatim that slide. That, my presentation today is going to be a little bit of reading the information on the PowerPoints and a little bit of additional commentary. This definition of stalking, this is the civil definition of stalking for purposes of the DVSA. It's basically verbatim the same definition of criminal harassment in the Criminal Code of Canada. So again, if we have any lawyers or service providers who deal with victims and they're involved in the criminal court system, just letting you know, our definition of stalking under our DVSA is basically the same as what the Criminal Code defines as criminal harassment. Next slide, please. So the Act gives some examples of what constitutes stalking behavior. And again, these are all kind of your classic elements of what most people would consider and recognize as stalking. Following the other person from place to place or anyone known to the other person, communicating directly or indirectly with the other person or contacting them or anyone known to them, using the internet or other electronic means to harass or threaten the other person. Now, I don't need to probably go into much more detail on that. That's obviously a burgeoning area that's been probably one of the main areas of stalking, in terms of cyber stalking, that has existed probably for 10 or 15 years. So the Act kind of specifically recognizes the use of the internet and other electronic means as an example of stalking behavior. Watching any place where the other person lives, works, or operates a business or happens to be. And then finally, engages in threatening conduct directed at the other person or anyone known to the other person. Again, kind of all of the elements of what, for the most part, most of us do think of stalking behavior to be. Next slide, please. Okay, so moving on from some of the definitions or terms that are in the Act, a little bit of information on applying for a protection order. So a judicial justice of the peace, or JJP, hears and determines an application for a protection order. And in very simple terms, if the application does not meet the criteria in the DVSA, the JJP cannot grant a protection order. As I've mentioned already, the application to a JJP is made without notice to the respondent, again, because of the seriousness or urgency of the situation. The standard of proof applied by a JJP when they hear the evidence on a protection order application is the civil law standard of a balance of probabilities, and not the higher criminal standard of proof beyond a reasonable doubt that's used in criminal court proceedings. So proving something on a balance of probabilities means that it's more likely than not to have happened. So again, to give you an idea, basically, if you have an allegation of an assault in a criminal court process, the prosecutor needs to prove that the incident happened and satisfy a judge beyond proof beyond a reasonable doubt. The civil standard of a balance of probabilities is a slightly lower threshold, and the JJP or judge in the Court of King's Bench would apply the balance of probability standard of proof for proceedings under this Act. Next slide, please. Okay, I'm gonna deviate here a little bit just because I think we may have, I'm backtracking a little bit. One of the previous slides, because I can't remember if I specifically addressed in my conversation the statistics of the poll that Lori had at the outset, and I thought that slide was going to be coming up, but I do see that we've covered it. So one of the points, I'll just mention it here for posterity since we're being recorded. 40 to 50% of applications for protection orders are granted by JJP. So that means that basically 50 to 60% of applications are denied. Okay, so thank you. So how's an application made? So an applicant fills out a protection order application form, and then they swear it or affirm it in front of a staff justice of the peace or a commissioner for oath. So the application forms are available on the Manitoba Court's website. And so what this means is that if someone knows that they're going to be applying for a protection order, and let's say maybe they are in shelter or otherwise working with a counselor or other service provider who's assisting them deal with their issues related to the DV or the IPV, it may be that the organization that they're dealing with already has printed off copies of the application for a protection order. Sometimes a person who needs to apply for a protection order may complete the form with or without the assistance of a service provider, for example, but they may complete it before they actually attend at the law courts in their municipality. Other times, if they don't have access to the protection order application form ahead of time, they'll simply have to attend to their courthouse and speak to someone at the provincial counter. They'll be granted or given, a blank application, and they'll need to complete it at the courthouse. Now, the application form itself consists of two parts. There's the one-page application form, and then the written evidence in support of the application. It's all together constitutes one document. The application for a protection order can be made in person by the applicant. It could be made in person by a lawyer, peace officer, or a protection order designate with the applicant's consent. And I'll discuss protection order designates or pods a little further in a minute. And then finally, the Act also allows for an application for a protection order to be made and submitted to a provincial court by telecommunication, by phone, email, fax, or the internet. And again, that can be video conferencing even in today's day and age. But those applications have to be submitted by a lawyer, a peace officer, or a pod with the applicant's consent. Now, the most common type of way that an application is made would be in person and either by the applicant themselves or perhaps with someone who's assisting them. Now, a protection order designate is generally someone who works in the field. It's a service provider who works with an organization that provides services to victims of domestic violence or family violence. And they have had one or more members of their organization go through the specific protection order designate training that Manitoba Justice offers and puts on a couple of times a year. So what it is, it's a little bit more in-depth training of processes under the Domestic Violence and Stalking Act than what we're going to be reviewing today. For example, we cover it off over 3 afternoons, and if the person from an organization completes the training and then passes a test at the conclusion of it, they are certified as a protection order designate on behalf of their agency or organization, and then they are able to assist an applicant, a victim of domestic violence, apply for a protection order, or they can even submit it on their behalf if for some reason the applicant isn't able to attend at the court. Now, for most of my comments for the rest of this afternoon's presentation, I'm really going to be talking about the standard scenario that we see most of the time, which are in-person applications at a courthouse, either made by the applicant themselves or by the applicant, but perhaps with a protection order designate who may be with them and assisting them with the application. Next slide, please. Okay. The protection order hearing process. And again, this is a bit of a general description. So after a protection order application, and like we talked about, it consists of 2 parts, the 1-page application itself, and then the written evidence in support, which is kind of akin to an affidavit for those of you that have ever had to sign an affidavit that maybe a lawyer has prepared for you. But it's basically your story written out, and then you're swearing or affirming to the validity and truthfulness of the information that you've provided. That gets filed with the provincial court counter, usually a staff person like a staff justice of the peace. And then at that point, depending on where you are, most of my comments are going to be a little bit Winnipeg centric. Then you're basically waiting. So usually on any given weekday at the Winnipeg law courts, they may have a couple of staff, JJPs, who are dedicated to just dealing with protection order applications. And after an application has been received and reviewed by a staff justice of the peace at the counter, basically then the applicant just has to wait, and sometimes it may be half an hour or an hour, sometimes it may be several hours until the hearing can be held before the justice of the peace, before the JJP, I'm sorry. And that's really, to be honest with you, simply just a product of how busy and how many protection order applications have been made to that particular location on that particular day. But by and large, it's important for you to know that when an applicant submits an application, they are probably going to be waiting, part of a morning or an afternoon until the actual hearing takes place. So what occurs is that when a JJP is available, they will review the application and the written evidence. And then what happens is that the applicant is brought into a small hearing room that is the JJP's room for purposes of the protection order application, and a hearing will take place before the JJP where the applicant will give verbal evidence. Now, for the most part, in my experience, the couple of protection order hearings that I've sat in and information that I've heard from JJPs over the years, for the most part, they're often just asking additional questions that are meant to get some further information from what an applicant may have already indicated in their written evidence. So It's not going to be like you're going to be going through a completely new hearing. It's really probably just going to be expanding upon and providing further clarification for some of the information that may have been provided in the written application. All verbal evidence given at a protection order hearing is given under oath and the hearing is recorded. And we always provide this caveat when we're doing the protection order designate training, and the JJPs generally do it as well. They indicate to an applicant before the formal hearing starts that if there's any information that you do not want the respondent to know and that you want to be kept confidential, such as if you've fled from a home and you are now in a shelter, or you've gone to maybe a family friend where the respondent does not know where they are, any information that you do not want the respondent to know about, you have to be aware not to mention where you are, for example, during the verbal evidence portion of the hearing. And the reason for that is because ultimately the respondent is entitled to get a copy of the evidence that's been presented to a JJP, and they're entitled to order a transcript of the oral or viva voce evidence. That's the verbal evidence that the applicant gives before the JJP. So just important to know, just something to be aware of, that all of the evidence is recorded. The JJP generally makes everyone aware of that. There's a legal obligation for an applicant to provide all relevant facts, even if they think that that makes them look bad. Now that may be kind of obvious, but there's an even greater onus on an applicant to meet that standard when it's a without notice application. And again, because it's a marked departure from the way that our legal system normally operates, where both parties to a court proceeding have notice ahead of time and they both have the right to attend and sort of have their position taken into account by the hearing officer, there is this onus for an applicant to make sure that they disclose all relevant facts, even if they think that it makes them look bad. So the example that we often use is, if the person who's applying for a protection order was involved in a skirmish where basically, let's say there was a bit of mutual abuse or verbal abuse towards one another, even if maybe the person who's applying for the protection order got the worst of it, they are still better off disclosing that maybe, there was some mutual slapping or pushing or hitting, whatever the case may be, because if it ends up coming out upon a review, upon a set-aside application, for example, by the Court of King's Bench, that an applicant did not fully disclose all of the relevant information at a protection order hearing, then that in and of itself could potentially be grounds for a King's Bench judge to set aside the protection order that might be granted. A couple of other provisions that are in the Act: the JJP may adopt any procedures that they consider appropriate to put an applicant at ease and to help the applicant understand the process. And the applicant is allowed to be accompanied at a hearing by a support person, such as a family member, a friend, or a pod. Now, unfortunately, during COVID, when there were severe restrictions put in place, not just through the court process, but in society in general, that provision was generally suspended. But it's my understanding now that the courts have been fully reopened that the applicant is allowed to be accompanied by a support person. Next slide, please. Okay, so what is the role of the JJP in the hearing? And, in general terms, the Judicial Justice of the Peace is an independent judicial hearing officer, very much like a provincial court judge or a Court of King's Bench justice. So their role is to be fair and neutral. The JJP cannot act as an advocate for the applicant. And even though I just finished saying a minute ago that the JJP can adopt informal processes, or they can explain some of the application process to the applicant, they're not there to assist them in getting the protection order. They're there to put them at ease, but otherwise to hear the applicant's evidence and then apply the provisions in the Act. So one of their obligations is to protect the rights of all parties involved. And that might sound a little odd given that the respondent is not present, but what we mean by that is, as we've already talked about, there are certain checks and balances in the Act. For example, not everybody can apply for a protection order on grounds of domestic violence. I mean, you cannot, if you get into a fight with a stranger or with a person that's just a casual friend, you can't rely on grounds of domestic violence. So that's what I mean, is that the JJP needs to apply the criteria in the legislation in an impartial fashion to ensure that the rights of both parties, to the extent that they're provided for in the legislation, are protected. The role of the JJP includes making a decision based on the facts, and that's the evidence that's presented. So it's the written application and written evidence, as well as any verbal evidence that takes place at the in-person hearing. They have an obligation to make a decision to grant or deny a protection order on the very day that the application and hearing takes place. So unlike, again, a provincial court judge or a King's Bench judge, where they may go through a hearing, they may want to take some time to think about it, so they'll reserve their decision and ask the parties to come back maybe in several weeks. That doesn't happen with a protection order process. If a JJP needs to take a few minutes, they may take 10 or 15 minutes just to review their notes and the evidence again, but the decision is going to be granted the very day that the application has been made. And then finally, they also have an obligation in the legislation to provide verbal reasons for their decision. So, well, I've heard many times that if an applicant is denied a protection order, all they unfortunately hear and take away is that they haven't been granted a protection order, and anything else that the JJP says may not resonate with them or stay with them. Nevertheless, the JJP is supposed to provide brief verbal reasons on the record, meaning they're to say it in open court where it's recorded, to provide reasons for their decision, be it to grant a protection order or to deny a protection order. Next slide, please. Okay, so now we're moving into some of the, what are the criteria? What needs to be considered by the JJP in order for a protection order to be granted? So just, briefly by review, we've talked about some of the key concepts, some of the key meanings. We've talked about, to some extent, the application process and the hearing process for getting an application for a protection order before the court. I've talked about the fact that a JJP has to consider the evidence that has been submitted, both in writing and at the in-person hearing, and then they have to apply the provisions in the DBSA in order to determine whether the protection order should be granted or not. So specifically, one of the sections in the Act that's basically replicated on the slide lays out a four-step criteria or four-part criteria that the JJP needs to determine in order to grant a protection order. The first one is that the respondent is either currently or has been committing domestic violence or stalking against the applicant. The second one is that the applicant believes that the domestic violence or stalking by the respondent will continue or start up. So step B in the process is basically the applicant's subjective personal belief. The applicant believes that the domestic violence or stalking will continue or start up again. The third step in the criteria is that the applicant requires protection because the court determines that there's a reasonable likelihood that the respondent will continue or resume the domestic violence or stalking. So again, B is that the court has to find that the applicant themselves believes that the DV or stalking will continue or start up again. The third element to the criteria is that the court has to determine on an objective basis that there's a reasonable likelihood that the respondent will continue the domestic violence or stalking. So, I know we're kind of all asking, why are there sometimes when applications are denied? And it's generally because they don't meet the elements of this criteria. And then the last one is that the protection order should be made without delay because of the seriousness or urgency of the situation. So I'm not going to go through this in much more detail, except, as I say, suffice it to say that if a protection order is not granted, it's often because the evidence is lacking or because the JJP determines that the four steps in the criteria have not all been met. So, that doesn't mean that A and B, for example, haven't been met. It doesn't mean that the JJP may be able to determine that domestic violence or stalking has occurred and the applicant themselves perhaps believes that it's going to start up, but that's not sufficient. The JJP also needs to find that that the court's determining that on an objective basis that there's a reasonable likelihood that the DV or stalking will continue or start up, and then finally that the protection order should be made without delay because of the seriousness or urgency of the situation. Next slide, please. There are some additional risk factors. There are 9 risk factors that are enumerated in the DBSA that a JJP must take into account. So it doesn't mean that any of these risk factors in and of themselves are going to be determinative of whether a protection order should be granted by the JJP or not, but it just provides broader criteria that the provincial government wanted to include in the legislation to require that a JJP must consider and basically draw their mind to these other risk factors, because they're basically very common red flags that are indicative of DV or stalking type of behavior, or on sort of on the cycle of violence, that they're basically warning indicators that it could occur. So I'll just quickly go through the 9 risk factors that are in the Act that a JJP must take into account. The first one is the history of domestic violence or stalking committed by the respondent. Now, you read that and you think, okay, that means, yeah, the domestic violence or stalking that they've committed against the applicant. That's the obvious conclusion, but it could be any type of domestic violence or stalking. So if the respondent has a history of doing this, if they've had convictions, for example, that might be something that the applicant might want to put into the application. The nature of the domestic violence or stalking. And again, I'm not going to go into this in detail, but the nature of it, is it a threat, or was the victim unfortunately seriously beat up? So what was the type of domestic violence or stalking committed? Whether the domestic violence or stalking is repetitive or escalating, whether the domestic violence or stalking is part of a pattern of coercive or controlling behavior towards the applicant. Other previous incidences of violence committed by the respondent, including any violence against animals. I've heard many times over the years from service providers who work in the field that violence against animals is a real red flag or a precursor that a person in a relationship with that type of abuser is definitely at risk, at high risk perhaps, to be abused themselves. Next slide, please. Okay, any mental health concerns involving the respondent. So again, the issue of the respondent's mental health may not necessarily be key to how they behaved in a certain incident, but this is the opportunity for the applicant to provide any information about any mental health concerns that they may have about the respondent. The current status of any relationship between the applicant and the respondent, including any recent separation or intention to separate. And then finally, the last two, the second last one is particular to the respondent. Any other circumstances of the respondent that may increase the risk to the applicant, such as substance abuse, employment or financial difficulties, or access to firearms or other weapons. And then finally, the last risk factor are any circumstances of the applicant that may increase the risk to themselves, such as pregnancy, age, family circumstances, health, or economic dependence. Now, what I will say is that I'm sure that there's many on today's call who've actually gone through a protection order application before or assisted someone. But for those of you who haven't, the protection order application form, there's literally a question on, there's a question on the protection order application pertaining to each of these 9 risk factors. So in other words, the application flows in a certain way that it's meant to assist the person applying for protection order to address some of these risk factors in providing responses to questions. So a person can put anything that they feel is relevant in their written evidence for a protection order, but the manner in which the application form, when it was last revised a number of years ago, it has questions pertaining to each of these risk factors. Okay, at this point, I know that Lori wanted to do another poll question, I believe, before we move on to the next couple of slides.
Yes, Maury, thank you. And I apologize for my glitches with the slides earlier. So what about this? Does anybody want to take a guess? In light of what Maury has just said about the risk factors, Can you get a protection order against someone while they are in jail?
Or to maybe word it a different way, would the fact that a person is in jail somehow mean that the JJP is not able to grant a protection order?
Few more votes coming in. And this one, the answer will be more proximate to the poll. Okay, I'm going to end the poll and I'm going to show the results.
And of course, the 90% are correct. The fact that the respondent is in jail would not prevent a person from seeking a protection order or a JJP from being able to grant one. Okay, next slide, please. And that question, that poll question, leads us into the next couple of slides under the heading of circumstances that are not a factor. And what this means is that there's a provision in the Act that says that even if certain circumstances exist, the JJP may still grant a protection order. So there's 6 of them. The first one is if a protection order has been granted against the respondent before, regardless of whether the respondent has complied with that order or not. The applicant and the respondent no longer live in the same residence or the same community. The respondent is in jail at the time that the application is made. Next slide. And then the last 3 circumstances that wouldn't be a barrier to a JJP being able to grant a protection order are criminal charges have been laid or may be laid against the respondent. The applicant is residing in an emergency shelter or other safety place. The applicant has a history of resuming a relationship with the respondent. So just before we move on, looking at D. So for example, a lot of times when there's been a domestic incident, if a respondent has been charged, we're all aware that there will often be, if they're granted bail, if they're not held in custody, they'll often have conditions attached to their release, whether they're in the form of what we call a recognizance or undertaking or actual bail conditions. But the type of conditions that can exist in a bail order made by the criminal court are very similar to the conditions that can be found in a protection order. And the most common ones would be your standard no contact, no communication with the complainant, who would be the applicant in a protection order. It's important to know that even if the respondent has been charged criminally, and even if there is a criminal court order out there in the system that prevents them from having contact or communication, that in no way prevents the victim or the applicant from being able to still apply for a protection order. And as we've talked about, a protection order lasts for 3 years, and the criminal court process may or may not, have been concluded in a satisfactory way that would allow the criminal court conditions to remain in effect that long. So just something to bear in mind. The fact that criminal charges have been laid is not a bar to seeking a protection order. Next slide, please. Thank you. Okay, so now we're going to move on to what can be included in a protection order. So again, and I warned Lori that I was going to do this from time to time, where I take a minute to kind of summarize what we've covered so far. So we've talked about obviously the application process. We've just finished going through the specific criteria that the JJP must find and that they have to take into account under the Act in order to be able to grant a protection order. So an applicant goes through all of that. They've completed their application, they go through the hearing process, the JJP goes through their process, and they determine that domestic violence or stalking has occurred and that the other criteria under the Act have been met, and accordingly, they grant a protection order. What conditions can be included in a protection order? Now, because it's a without notice application, there are only 7 specific conditions that a JJP can possibly include in a protection order. They don't have the discretion to deviate from this list of 7 possible conditions. So that's what I was previously talking about when I was referring to sort of checks and balances within the system. Unlike, for example, a judge of the Court of King's Bench who has broader discretion, the DVSA prescribes certain parameters for what a JJP can do in terms of a protection order. And so they have 7 conditions, and the first 3 are what I am calling the standard conditions that you will generally find in pretty much each and every protection order that's granted. And those are the conditions that the respondent may not follow the applicant. The respondent may not communicate with or contact the applicant. So their standard no contact, no communication. And the third standard condition is that the respondent cannot attend at or near any place the applicant happens to be or regularly attends. Specific examples of that would be things like where they live, where they work, or where they go to school, or their place of worship. Now, the second and third conditions, that the respondent cannot contact or communicate with the applicant, or that they cannot attend at or near where the applicant happens to be or regularly attend, are subject to a couple of specific exceptions. And that is that in the scenario of a court proceeding in which the respondent is a party or an accused person, or in relation to court-ordered mediation or assessments, for custody or access, in those scenarios, the respondent may be able to have contact or communication with the applicant in the context of a court process, or they may be able to attend at or near where the applicant happens to be. So again, if we're talking about a scenario where the respondent is a party to the court proceeding and the applicant happens to be there, the only type of civil court proceeding that would normally come to mind would be a family court proceeding. And then an accused person, well, that would probably be where the applicant is the complainant. So you can see these are, in my view, these are common sense exceptions where, you know, an applicant has the right to go to court, as does the respondent, for proceedings that they're involved with one another, or in relation to mediation or assessment services that may be provided by, for example, our family resolution service, or maybe a private mediator in relation to custody or access. So those are very narrow exceptions where they would be allowed to have contact or communication with one another. Next slide, please. Okay, so the remaining 4 conditions out of the list of 7 in the Act are the conditions that generally you're not going to find in every protection order. And normally the JJP is only going to include some or all of these additional conditions if they've heard evidence from the applicant, either in the written evidence portion of the application or in the verbal evidence portion of the in-person hearing. They need to hear evidence that basically causes the JJP to conclude that they need to include one or more of these last 4 clauses, that for them to determine that it's necessary or advisable for these clauses to be included. So the 4th one, or the first of the clauses that aren't typically included, unless there's a specific need and evidence to support it, would be that a police officer can remove the respondent from a residence. Now, this particular one, if you had a situation where the parties were living together, and if the applicant basically has fled the residence, and if their evidence is that they don't intend to go back, that they're in a place of safety, and that all they're really concerned about is retrieving their personal items, then this condition probably wouldn't be included. If you flip that on its head and you have a situation where maybe, you know, say a woman owns her own home and her partner moves in, and there's a domestic violence by him towards her. That may be an example of where, you know, she may say in her application before the JJP that, you know, it's my home. I bought the home 4 years ago. He's only been living with me for 6 months. It's only my name on the home. I make the mortgage payments. That could be an example of where the JJP may determine it's appropriate to include a condition that the police should remove the respondent from the residence. The next condition is that the applicant be granted temporary possession of necessary personal effects. So what constitutes necessary personal effects? Things like your ID, your passport, financial documents, maybe essential clothing, medication, your laptop, car keys and vehicles. So these clauses are meant to sort of supplement the core provisions or conditions in the protection order to you know, provide further enhancement or further scope of protection to the applicant. The JJP is not supposed to be dealing with marital property issues or family property issues, for example, in a protection order. So you're not going to see a situation where, the JJP asks, okay, what other items are in the home? And, the person says, well, we bought a TV and a stereo together. And the JJP says, okay, you're allowed to take the TV out of the home, but you got to leave the stereo. That's not going to be there. I'm just using that, sort of as an extreme example to highlight the point I'm making, that it's possession of necessary personal effects. And I've given you sort of the main types of categories of what type of items might constitute necessary personal effects. And then finally, the last condition, I shouldn't say the last, I'm sorry, the second last condition, which is kind of a companion provision to the clause before that dealing with possession of necessary personal effects. The JJP can include a provision that a police officer can accompany the applicant to the residence to supervise the removal of personal effects. So I can't tell you this definitively, but my educated guess is that if a JJP feels that they need to include a condition that the applicant be able to attend at the home and remove certain items to have to have temporary possession of those effects, they're also going to include the clause that a peace officer should accompany the applicant to the residence to supervise the removal of those effects. Next clause, please. I'm sorry, next slide, I'm sorry. Finally, the last condition is the one that deals with firearms and weapons. So there's a provision in the DVSA that states that if a protection order is granted, and if the JJP determines that the respondent is in possession of a firearm, the order must include a condition that any firearm and ammunition in the respondent's possession be delivered up to the police until a further court order or disposition is made. If the respondent does not cooperate and turn over their firearm or firearms and ammunition, then the police are authorized by the condition for purposes of seizing the items to enter and search any place where the officer has reason to believe that the items are located. Now, this is an important amendment that came into the DVSA back in 2016. Normally, the condition that existed in the legislation before that generally required that the JJP needed to hear evidence that the weapon, be it a firearm or something else, was used in the commission of the domestic violence or stalking. And if that occurred, then you'd often have a situation where the JJP would include a condition that the firearm and ammunition or other weapon needs to be turned over. When the DVSA was last amended in a substantial fashion in 2016, it includes this provision that basically says if a protection order is granted, so the JJP has to include that domestic violence or stalking has occurred, and then separately from that, whether a firearm that the respondent is in possession of was used in the commission of the domestic violence or stalking or not. There's a mandatory provision in the Act that if the protection order is granted and the JJP determines that the respondent is in possession of a firearm, then the order must include this condition that the respondent turn over any firearm or ammunition in their possession, failing which the police are authorized pursuant to the wording of the clause to enter and search any place where the officer has reason to believe the items are located. So for purposes of this provision, there are also specific questions, I think I'll say a couple of questions relating to whether the respondent is in possession of a firearm or other weapons that are in the application. So what I mean by that is, just like I referenced with the risk factors, there's a couple of specific questions to sort of draw or avert the mind of the applicant to specifically provide information as to whether the respondent has a firearm or other weapons. And again, it's still one of these conditions that are part of the last four conditions that were not automatically included in all protection orders. We're generally only included if the JJP hears the evidence that they need to hear in order to determine that any of these last four conditions can be included. And then the companion provision to that is that the protection order can also include a condition that the respondent must deliver up any other specified weapon in their possession. So that can include really anything. Anything can really be a weapon, right? But we're really thinking things like machete, a knife, bear spray, brass knuckles, a baseball bat. I guess anything that a respondent might use as a weapon. They either have to turn it over or until a further court order is made, or failing which the police have the same search and seizure authority as they do with respect to firearms. Next slide, please. Okay, so I've finished what I'm going to call really the core part of my presentation, and that's really the review of all of the relevant provisions pertaining to protection orders in the DVSA. And again, I'm not going to sum it up for you. I've kind of been doing that, but we've sort of gone from, what are some of the meanings for things like domestic violence or stalking in the application process, all the way through to, what the JJP must consider in order to be able to grant a protection order. And then if they do grant a protection order, what conditions they can include as part of the protection order that's been granted. So a protection order is granted. What happens next? So I've already alluded to the fact that, at the conclusion of the hearing, if it's granted, the JJP will indicate that and provide verbal reasons, and then they will have the applicant wait 15 to 30 minutes at the courthouse while the protection order is being prepared by provincial court staff. And basically, if a protection order has been granted, the applicant will walk out of the courthouse that day with their protection order in hand. The other thing that happens concurrently is that court staff will register the specifics of the protection order on a national police database called CPIC, which is Canadian Police Information Center. So some of you on the webinar today probably are familiar with CPIC as a police database, but the point is that the information is entered by court staff. I think it's within 24 hours. I may be wrong, it may be even quicker than that, but the point is the information is entered so that thereafter any police agency in Canada has access to at least a written summary of the key parts of the protection order, the parties to the order, what the main provisions are. I don't believe that they scan in actual copies of the protection order. They would be unable to do that given the number of protection orders I think that are granted across Canada. But the salient points of the protection order and the terms of it are available for police to access. We've talked about the fact that a protection order typically expires 3 years after the date it's granted. However, the JJP does have the authority under the legislation to grant it for longer if they feel that that's necessary to address the domestic violence or stalking. In my experience, I think I've seen one protection order over the years that was granted for more than 3 years. So I think we can safely say that, for all intents and purposes, your standard protection order is going to be for a 3-year term. And if you've ever seen a protection order on the top right-hand corner or somewhere in the top right-hand corner of page 1, it says very clearly date that the order was made and then date of expiry of the order. And of course, the expiry date will be exactly 3 years to the day that the order was granted. The Act does state that an applicant can reapply, for a further protection order within 3 months of the expiry date on the protection order if there's a continuing need for protection. So let's say an applicant gets a protection order during the course of the 3 years that it's in effect. Maybe the respondent breaches it on a number of occasions, or whatever the case may be. If the applicant feels that they have a continuing need for protection, they're able to apply for a further protection order, basically once you get to the 2-year, 9-year mark or beyond. Next slide, please. Okay, so what happens in terms of, in practical terms, how does a respondent find out that a protection order has been made against them? During the application process, the applicant provides, there's questions on the application basically about, do you know the whereabouts or the address or job location of the respondent? So the applicant provides as best information as they can. And of course, obviously, if they've been in a relationship, You're probably going to be able to give very specific information. If it's something different, like maybe a stalking case, maybe the applicant provides the best information that they can. And then at that point, it's up to the sheriffs or the police to do their best to locate the person. So personal service of the protection order is preferred, but the DVSA does say that a protection order shall either be served personally by the sheriff's office or the police, or if the respondent cannot be conveniently found, then they can serve them under the act by leaving the documents with an adult at the respondent's last known home or employment address. And they also have to leave a written notice stating, along with a copy of the protection order, stating that documents should be forwarded or given to the respondent as soon as possible. Now, this last bullet point in this slide is an important point. A protection order takes effect in favor of the applicant immediately upon being granted. So that means that they can contact the police and ask for assistance immediately as soon as they are granted that protection order if there's a breach. But the respondent is not bound by the protection order, meaning they cannot be charged with breaching one of the conditions until they're actually given notice of it. So just to use a very simple example, let's say an applicant gets a protection order, they go home, a few hours later before the respondent has been served, he's initiating contact. That could be everything from telephone or email to maybe showing up where the applicant is in person. She can call the police right away. The order is effective in her favor, and the police should be responding, and they should basically be enforcing it from the point of view of saying to the respondent, you're not allowed to be here, or you're not allowed to contact her. But until the respondent has actually been served in accordance with this act and has been given notice of it, they're not bound by it, so they wouldn't be charged with it. And it's really just a matter of fundamental fairness. How can someone be charged with an offense of an order that they didn't know was in existence? So hopefully that doesn't sound contradictory. It isn't, from the point of view of, the applicant can contact, they're now the protected party and have the order that's been made in their favor. So they can certainly phone the police and ask that they attend or whatever the case may be, or deal with it. But if the respondent hasn't actually been served with it yet, then I imagine that the police would notify them that an order has been made. Probably it's at that point that the respondent would be first finding out that they're not allowed to attend because an order has been made. Next slide, please. Okay, the set-aside application. And during the protection order designate training that we do, this is always a big topic. I've heard many times, that an applicant gets a protection order, they go home, and then they nervously sit by for the next 20 days and almost do a countdown before they know whether an application is going to be made or set aside. Now, from the point of view of lawyers on the call, we all know that, look, this was a without notice application. The respondent never knew about it. At some point, as exists in any without notice legal process, there's a right for the party who didn't have notice and didn't have a right to put their position and their evidence before the court to basically have the order reviewed. And generally it's reviewed by a higher court. So that's the case under a protection order. So what the DVSA provides for is that once a respondent has been served, they have 20 days to apply to the Court of King's Bench to ask that a protection order be set aside. And set aside application, they don't use the word appeal at all in the DVSA, but basically if a respondent files a set aside application, then that is their application basically saying that I think that the JGP granted this protection order in error, and I'm asking that it be reviewed by a King's Bench judge and set aside. If the respondent applies to set aside the protection order in the Court of King's Bench, then the applicant gets served with notice of the proceeding, including any hearing date. If the applicant wishes to oppose the set aside application, they should attend any court date and plan to participate in any court process. They can be represented by a lawyer or represent themselves. So think of it this way. Once a protection order is made, any further legal dealings with that order are going to always be dealt with in the Court of King's Bench. And then you are basically dealing with the rules of court process and the rules of evidence that exist in other civil, family, and criminal proceedings. And so, which is to say that basically it's going to proceed as a typical family court proceeding would, where one side files an application, they must serve the other side. Both parties have the right to basically participate in the proceeding, attended any hearing, and put their position before the court. Next slide, please. Oh, okay. We'll finish off the set aside. Yeah. Okay. So the protection order remains in effect until the hearing is concluded, and this is relevant. So the provision specifically states in the DVSA that the filing of a notice of application, the filing of an application to set aside a protection order does not have the effect of staying the legal effect of a protection order. So the terms in a protection order remain in effect until the set aside hearing may be concluded. And as we've already talked about, proceedings in the Court of King's Bench, if they're contested, will often take several months or more to be concluded. The evidence that was before the JJP shall be considered as evidence at the set-aside hearing, and the applicant may also present additional evidence. So to put that in layman's terms, the application form that the applicant filled out at the protection order application for the JJP, their written evidence, and then ultimately a transcript of their verbal evidence during the in-person hearing before the JJP will all be provided to a judge of the Court of King's Bench and considered. But in addition to that, the applicant is also entitled to present any further additional relevant evidence that they wish the judge to consider. Obviously, the respondent has also filed their own evidence, and a lot of times these set-aside applications, although they are grounded or initiated by the respondent filing an application with an affidavit, they often end up turning into like a one-day trial, a half-day or a full-day trial in front of a King's Bench judge, where it's again in-person or verbal evidence, or what we call it's a viva voce hearing, where the parties come to court and they take the stand and they give their evidence under oath. At the conclusion of a set-aside application, the court can confirm the protection order, which means they basically let it stand as it was granted by the JJP. Alternatively, they can set aside or cancel the order entirely, or the third option is that they can maintain the order in effect, but they can vary or change some of the provisions in it. They can either delete some clauses if they feel that's appropriate, or they can add some of the additional clauses that could have been included amongst that group of 7 clauses. Next slide, please. Okay, finally, the last part of our application. So what happens if a protection order is denied? What are the other options for a victim of DV or stalking under the legislation? The first bullet point is an important one. If an application for a protection order is denied, the applicant can always come back to court and apply for a protection order if there has been any new or further instances of domestic violence or stalking since the initial protection order application was dismissed. What you cannot interpret that to mean is that a person comes to court, they apply for a protection order, it's dismissed, and then a day or two later, with no further incidences or fresh evidence, if you want to call it, they can't go back and reapply for a protection order on the same evidence that they relied upon at the initial hearing that was denied, hope that they get a different JJP and that it may be granted. There's very specific questions on the application in which you have to advise whether you have applied for a protection order in the past or not, and whether one's been granted. So you can't really, get around that. However, if, like I said, if there have been further instances of domestic violence or stalking, you can absolutely come back. I've seen cases where someone comes back within a matter of a couple of days that their initial application for a protection order has been denied, and they end up being granted a protection order. The other primary option that we've alluded to at the beginning of our presentation for a civil protection order under this legislation is for a person to apply to the Court of King's Bench for a prevention order. We've already kind of described some of the characteristics of the application process for a prevention order. It's more formal. Having a lawyer is desirable but not necessary. Takes much longer, unfortunately. It's generally intended to deal with circumstances that are not considered serious or urgent in nature. The court can make a prevention order where it determines that the respondent has stalked the applicant or subjected them to domestic violence. Now, you may be thinking, well, kind of duh, that seems kind of obvious, but really when you think about it, it's very nuanced. Think of it this way. The JJP, we talked about what the meanings of domestic violence or stalking are, and they apply for prevention order applications as much as protection orders. But whereas the JJP has that 4-step test for the criteria that they have to find exists, again, because it's a without notice application, so the legislation provides very specific parameters that guide a JJP's consideration of whether to grant a protection order or not. A judge of the Court of King's Bench has much broader discretion under the prevention order provisions of the DVSA. I don't want to say merely, but they have to find that domestic violence or stalking has occurred. It's not quite as arduous a process in terms of, is it still going on? Does the applicant subjectively believe that it's going to continue? Does the court determine on an objective basis that DV or stalking will continue? It's simply the legislature has determined that it's appropriate to give judges broader discretion. And so they have the authority where they've determined that there has been domestic violence or stalking, they can make a prevention order. And that's the criteria, simply put. Next slide, please. This is the last slide of my, this is the last substantive slide of my presentation. So a prevention order can include any of the same 7 conditions that a protection order can include, being granted by a JJP, as well as any other conditions that the judge considers appropriate to protect the applicant or to address the domestic violence or stalking. So even though the Act says the judge can grant any type of conditions, it does go on to add a non-exhaustive list, and those are the ones that are referenced with the bullet points below that. A few of the key ones are, for example, seizure of items used by the respondent to further the DV or stalking. So really, when you think of it, I mean, stalking in today's day and age can be your classic, the guy's parked in his car half a block down and staring at his ex's home. It can be photograph or videotape equipment. It can be computer equipment. There's another provision that a judge can recommend or require that the respondent receive counseling or therapy. The respondent can be ordered to pay compensation to the applicant for any monetary loss suffered by the applicant or any child of the applicant as a result of the domestic violence or stalking. Finally, suspension of the respondent's driver's license if the court is satisfied the respondent drove a motor vehicle to further the domestic violence or stalking. And then finally, the last main aspect of a prevention order is that, like all King's Bench family court orders, they don't have an expiry date. They remain in effect indefinitely until they are reviewed and then possibly terminated or revoked by a subsequent Court of King's Bench order. So a prevention order could potentially remain in effect for a long period of time until they may finally be reviewed on an application brought by one party or another. Okay, next slide. And so thank you everyone for coming. I know I went a little bit over. I was hoping to finish by about 1:15, but as Lori has said, I'm more than happy to stick around for a while after 1:30 if those of you that are still on the call have the ability to hang on and if you have questions. So thank you, and I hope that you enjoyed the presentation.